Good evening, everyone. Thank you for allowing me the opportunity to speak. My name is Frank Sicoscio. I am president of the Rhode Island Second Amendment Coalition. There are a lot of bills on here that we support, and there's a lot of bills that we oppose. I would ask the chairman how he'd like me to proceed in testifying on these.
It's totally up to you, Frank. I know we have 14 bills. You probably have something to say about all of them. So if you want, however, whatever order is best for you, just feel free to proceed.
I'll start off with Bill 7799. The firearms community, we oppose this bill for a couple of different reasons. The language is being stricken from this bill, this is the language we actually worked on. We submitted this type of language to protect individuals that had firearms that had any type of mark or any type of problem with the serial number on it. It offered the individual an opportunity to have the firearm recertified so that that individual would not be in violation of the law, so they wouldn't be charged with altering a firearm. What happens when you strike the language, according to subsection C, you create a prima facie evidence that the individual in possession of the firearm altered it. There are a lot of firearms that people use to go hunting, to go out in the woods. You could drop them. There could be a mark on them. That could be interpreted as somebody altering a firearm, when in fact we put this language in this bill to protect people, and now it's being stricken out of the bill and puts the burden on the law-abiding individual to try to prove differently, when there was this very easy, simple certification process. Now, there's a lot of firearms that were made prior to 1968. There are no numbers, no modification, no marks on them at all. 1968 Firearm Act required manufacturers to put marks on them. There's nothing in this bill to do that, and I heard the Representative Maldonado said she was going to put an amendment on there, and she should put an amendment on there because there are a lot of individuals, collectors, that have very valuable firearms that are old, and there's no marks on them. But they've owned them for years, so that would be in there. The problem in this bill, when you strike the language of that, I've just gone over it. The bottom part, we don't have any problem with. If somebody has a firearm or a plastic toy and they take the orange marks, identifications off and make it look like a real firearm, we don't have a problem with that. Those marks are put on there specifically so an individual knows very quickly when they look at it that it's a toy. So we don't really have a problem with that. It's just striking the language in there that we put in. That's the reason why we have a problem with 7799. Turning to House Bill 7680, the Second Amendment Preservation Act. This bill we are in support of. This is a bill which it's a little bit difficult to follow, and if you're not an attorney, you don't know how these things work in here between the separation between the federal government and the state, so it's a little bit different. This is basically an anti-commandeering act. What it will do on this is it keeps Rhode Island separate. So Rhode Island, the state can always help the federal government, but they can't be compelled to do it. So there is a way. This bill, the way it's written right now, we actually support this bill, and I know Representative Nardillo did a very good job of going over this bill. So I'm not going to spend a lot of time on it, but we do support this bill. House Bill 7535. Took a long time going over this bill. Oh, but let me start off by the firearms community. We do not support this bill for a couple of different reasons. I'll explain to you why. When you take a look at the bill initially, you have to read it over several times to find out what they were doing with the bill. There's a whole section on the top that had all different exemptions in it for an individual. So if they wanted to go hunting, if they wanted to go to the range, it's not criminalized. So they strike all the language on the top, and then they pretty much put all of the exemptions back in on the bottom. The only real difference in this is they strike the word use on the top part of it. So let me explain to you what this bill actually does. If you remember back a couple of sessions ago, Jody Lindbeck from the Attorney General's office came in and she wanted a gang bill. That's what she wanted. She said that the Attorney General's office, it's so difficult if they come upon somebody on the street and you have a couple of gang members, they always hand off the firearm to a minor because the minor's going to get a slap on the wrist. The people that are above the age of majority, they walk away, and there's no problems with that they have a hard time. The Attorney General's office, if they had to prosecute somebody under this version of the bill, they had to first prove that the individual was in possession of a firearm, and then they actually used the firearm. So there has to be direct evidence the person either brandished the firearm, aimed the firearm at somebody, shot at somebody, or the Attorney General could not prosecute under this because they would not be able to prove one of the necessary elements of the criminal charge. So to make it so the Attorney General can have a gang bill is they took out the word use. So now all they have to prove is the person was in possession of the firearm and the person was a minor. The problem with this bill is it criminalizes the mere possession of a firearm. A lot of times when you look at a criminal statute, it'll have knowing in it, it'll have willingly. There'll be some type of element that they have to prove the person knew about it. All this does is say mere possession. Also, when you take a look at the unintended consequences of this bill, how are you going to answer your constituents when a 17-year-old boy or girl sets up a BB gun in their backyard and puts some tin cans on a box and shoots them off that tin can, and now they're violating this? They don't have a parent around. They don't have a guardian around. So a minor that simply has a BB gun, because BB guns in Rhode Island are classified under here as a firearm. This also deals with airsoft guns. So this would criminalize somebody sitting in their backyard with a BB gun just shooting tin cans, because it doesn't have the protections anymore when you start striking all this stuff out. Okay, so for that, this is the reason why we oppose this bill 7535. Turning to House Bill 7199, which is the magazine capacity ban. This would outlaw and make it a felony to possess any magazine which has the capacity of holding more than 10 rounds in it. Okay? Let me give you a little history on a bill such as this. In 1994, the federal government passed the United States Federal Assault Weapons Ban. That was a ban that was put in place by the United States government that outlawed whole classes of firearms and limited the magazine capacity of different type of magazines, and even went as far as to limit the magazine capacity of certain handguns. I know because the firearm that I regularly carry was a pre-ban gun, and when I had purchased it, I had to go out and I had to buy different magazines for it because they would exceed the capacity on it. So I know that there was, at that time, I had to purchase them, just be in compliance with the law. This federal law actually was allowed to lapse in 2004. And it was allowed to lapse because the federal government took a look at their own law they put in place. You know what they found out? Doesn't work. There is no negligible effect on reducing crime when you reduce the magazine capacity. A task force on community prevention service, which is an independent, non-federal task force, they've released a report that they found insufficient evidence of the effectiveness of the ban. That's a independent, non-federal task force. The government did the National Research Council also studied this ban, and they also determined that the assault weapon ban did not reveal any clear impact on gun violence. The reason being is a ban like this only affects the law-abiding citizens. Police and the military are exempt, and the criminals don't follow the law. So it doesn't have any effect at all on crime. The problem is we keep putting these bills, or wanting to put these bills back in place again. If anything, history is there to prove to us so we can learn and not make the mistakes over and over and over again. The magazine ban on here does not have a deterrent effect on crime. In addition, do you realize that this criminalizes the manufacture of magazines in Rhode Island? One of the oldest magazine manufacturing companies in the United States is right here in Rhode Island, and they manufacture these magazines. Under this bill, you're putting people out of work. They would have to close down because it's illegal for them to do that. Every politician I know campaigns on, we need to create jobs, we need to help the economy. So you are criminalizing the manufacture of something that other states can have too? We can't make it here anymore? So, in addition to that, the statement in here on the bill says police officers can have a magazine over 10 rounds if they're acting in their official capacity. So I ask you, what happens when the officer punches out and goes home? Can they have a 10-round magazine, or can they have a 30-round magazine at their house? They're not acting in their official capacity. Are they going to be felons? What about when the police officer retires? Do they have to turn in all their 30-round magazines they have, or 20-round magazines? You can't make an argument they're acting in their official capacity anymore. So you got to be careful with the wording on this, because you're making off-duty police officers could possibly be in trouble with this one. So take a look at the wording of the statute. Let's go to House Bill 7575. Okay. This is the Protect Rhode Island Families Act. Before I get into the details of the bill, I just want to say the Second Amendment Coalition, the firearms community, we do not condone domestic violence. But when you put in bills like this, they're too overreaching, they have unintended consequences, and therefore we have to oppose them. There are ways that we can do this, but not this bill. Let's go step by step through the bill. The first thing it does on the top, in dealing with 8.8.1-3, those are protective orders. Those are the ones that are issued by our family courts. First changes there is it changes may to shall. So what it does, right off the bat, it takes our discretion away from the judiciary in the event that they're going to be issuing a protective order. There is no longer any discretion by the judges. They issue a protective order, they have to order all the firearms turned over. In the first part of the bill, there's no requirement that there be a firearm was involved. It was brandished. It was threatened. The first part of the bill doesn't have any of that. The second part does, dealing with protective orders in district court. Restraining orders in district court, but the first part doesn't for protective orders. The concern I have with this, and the attorneys on the board understand this, when you go to family court, you're in a non-criminal venue. When a lot of the judges in family court, they'll err on the side of caution. If two people are there, they'll say, look, you stay away from this person, you stay away from that person, and they'll err on the side of caution and put a protective order in place. The problem with that is a lot of times you'll hear the judges say, I'm going to enter into the order, and I'm not going to make any findings of fact. I'm just going to put the order in place. So according to the wording of this bill, look at what the effect it has. You have an individual who probably has no criminal convictions at all. There is no finding of fact by any judge that they did anything wrong, but they're ordered to turn over all their firearms. You have a right to bear arms, which is a constitutionally protected right, taken away in a non-criminal setting, and there's no adjudication that they did anything at all because the judge says, I'm going to make no findings of fact. And the person has no criminal history. That's what this bill does. Goes a little too far, in my opinion, on that. The burden of proof also in a protective order in family court is less. We're not talking about beyond a reasonable doubt of a criminal. Family court is dealing with a different burden of proof. In addition to that, this bill we opposed in a different version because it eliminates a neutral third party being able to hold on to the firearms during the time that any protective order or any restraining order is going through. The reason why we keep saying this is a couple of reasons. One is individuals, most times if you talk to people that own firearms, they don't just own one, they probably own several. Some people own large collections. It depends. It's like anything else you want to collect. Some people collect firearms. The problem with a bill like this is if a protective order is put in place, what if an individual has their father's hunting rifle and their grandfather's shotgun? You really want to turn it over to the police department and hope it's going to come back in the same condition if something happens, or later on when the protective order is over? There are some people, and just to make sure everyone has a frame of reference, there are some people that really enjoy going out shooting trap, and their shotguns are in the neighborhood of $20,000, $25,000 or higher. If something happened to me and I had to turn over my firearms, I wouldn't want to turn them over to the police department. I would want to be able to turn them over to somebody that I know that has a very good gun safe, that could keep them safe, and would be court ordered, like we already have right now, that they can't turn those firearms over to me. It takes the firearms away from an individual. They are stored securely, and by the way, at no cost to the taxpayer. When you require every protective order to have somebody turn their firearms over, think of the cost now we're going to have for the state police and the local police departments to have to go out. They have to secure the firearm. They have to categorize it, take photographs, put it into a computer system. They have to store this, and then later on, they may have to just simply turn it over. So think of all the extra costs that we're going to have for the police departments and state police for doing this. Why are you taking the third party away? Third parties should be able to store the firearms and be subject to criminal penalties if they turn them over. It would save everyone in the cost. We had mentioned this several times when the versions of these bills came up, but they insist on taking out the third person on this. Now, the language in here states that the state police would have the final say into what happens with regard to the firearms. And in fact, the state police, according to the language that's put in here, would have complete discretion and could write rules and policies for the local police departments. So you're granting authority to the state police to tell the local police departments what they can't do with regard to storage and how they handle these firearms. The language in here says the state police may, if they want to, they can actually talk to the Chiefs of Police Association, but there's no requirement that they take any of their suggestions or whatever. State police, you're granting them authority, complete discretion on what to do with these firearms. Now, a couple of other things that I want to make sure we put out here. A lot of times the courts will grant mutual restraining orders. Somebody will come into court and they'll complain that they want a protective order against another individual because there's problems. A lot of times the judges will say, you know what, I'm going to grant mutual restraining orders. Everybody stay away from each other. What happens when one of those individuals that's going to court, asking the court for protection, is a victim of domestic violence, and the court orders the mutual protective order? You've just disarmed the victim in this case. You are now victimizing victims a second time. because it's mandatory. There is no discretion. You took out the word may and said shall. So there is really a problem with the bill on that. Now, one other thing I want to, and I know I'm putting a lot of time into this, and there's one other comment I want to make on 7575, and then I'll move on. I take a little bit of an exception to Representative Tansey coming here and throwing our judiciary under the bus. They do a very fine job in the court systems. There was never any information given that we saw that the 18,000 protective orders that they looked at, whether there were a significant number of those where the person asked that a firearm be removed and the judge didn't do so. My guess would be if there was 18,000 protective orders issued by our judiciary and only 5% had an order to remove the firearms, I'd be willing to bet our judiciary in all 100% of the cases where an individual said a firearm was used and this person has access to firearms and threatened me, that the judiciary ordered them removed. It's a little disingenuous to come here without the judiciary and in a roundabout way say that they are incompetent and they're not doing their job. So I have a real problem when the people throw the judiciary under the bus. I would like to see that information first before I would make a statement on that. But I really don't appreciate that. I have more faith in our judiciary. Let me move on to 7283. This is also another version of a bill which would criminalize possession of a firearm by a person convicted of a crime of violence or as a fugitive from justice. Again, the problem on this that we have with this bill is the wording could possibly bring in a person put on probation for domestic violence. In Rhode Island, a person placed on probation in a criminal setting, that's considered a conviction during the time that they're put on probation. But a probationary period successfully completed is a non-conviction. So when you use the word pleads and gets a conviction, you really need to tighten up the language, because that just doesn't go to a person who was adjudicated guilty and then would have a sentence at the ACI to serve or to be suspended. And I think that's what the intent of this was. So you clean up the language on that. This also runs afoul of another section of law that we have. The problem is it runs afoul when it gives discretion to a judge whether after the offense has been expunged, whether a judge can order that person not to own a firearm anymore. We have an expungement statute that says if a person actually is allowed to have a charge expunged, that once the expungement goes through and the order is there, that there are no penalties that remain with regard to that expunged case. The case is over. It's done. It doesn't even appear on their record anymore. It will be removed. This gives the judge discretion when they expunge that to say, I'm still going to order you not to have a firearm. So my question as an attorney, is that constitutionally valid when a case is disposed of and expunged, where there is a court order in place that the person should not have a firearm anymore? The person no longer has a criminal record. You know what the problem with this would cause? And we saw this problem a couple of years ago in Superior Court with judge shopping. Judge Lamphere in the Superior Court was really upset because people were looking to find out which times the judges were on vacation so they could put a plea through, because certain judges were easier on certain things than others. So, what if you have an attorney who says you can get the case expunged, but say it's close to September? What if an attorney says to a client, don't file the paperwork, because in every September the judges rotate, and the judge that you're going to be in front of, boy, that judge is harsh on these gun things. Wait till after September and they move, and you get in front of a different judge, and you can have your case expunged, and you won't have to worry about that. You got a problem with judge shopping if you do something like this, because one judge down the hall may say, I'll expunge it, and you're all set. Another judge down the other end of the hall says, I'll expunge it, but I'm going to grant an order that you can't have a firearm. Doesn't have adequate or very even application of the law when you put that in place. So that's the problem that we have with 7283. Moving on, trying to go as quickly as possible. 7243. Okay, I don't have the bill in front of me. All right. This is the one where it would remove the concealed carry holder's ability to go onto school grounds. And it would create a felony if they actually did go on school grounds. A version of this bill was put in last session, and it actually encompassed everybody. Police officers, off-duty police officers, sheriff constables. There was a lot of opposition. So they dropped it down to now just the concealed carry holders, and that is not appropriate. First and foremost, it should be disturbing to every person that's out there who has a child in school that we are trying to, or they are trying to extend the gun-free zones. Gun-free zones are a dangerous and antiquated notion that does not work. Did we not learn anything from the Paris shooting? Those people were completely defenseless in a gun-free zone. It doesn't work. This restricts law-abiding citizens from entering school grounds. The problem with this is they don't tell you the whole story. Right now in Rhode Island is approximately 3,600 concealed carry permit holders from the Attorney General's office. There is approximately 150 to 200 permit holders from all the different cities and towns. We have a population of over 1 million people. What is that? Less than 0.4% of the population, law-abiding citizens. They're the problem. Those are the people that they want to keep off the school grounds. That's the issue with this bill. People who are licensed by our Attorney General's office to carry a concealed firearm, they don't pose a problem. Why are we restricting them? Subjecting them to possible felony charges if they go on school grounds. Individuals that are licensed by our local police departments who we entrust to make sure that they enforce the laws that we have and protect us, they license people also. You want to subject them also to a felony conviction in the event they happen to go on school grounds? Now, we took extensive testimony last session on this, and I was there. I heard people driving in from Connecticut saying after the Sandy Hook shooting that a lot of the school departments in Connecticut went away from the gun-free zones and started putting armed security in their schools. They're getting away from the gun-free zones. What are we doing? We want to further the gun-free zones? We're going backwards in Rhode Island. What are we doing with this bill? We're putting our kids at risk. We're guaranteeing that if somebody was on the school grounds and had a concealed carry, in the event something happened, they could respond. You're guaranteeing that that person that goes on the school grounds can't carry. This actually happened to me. I went to Roger Williams Law School, and when I first started there, I could carry. You could walk in there, and there were police officers that were actually students at the time. They would sit right next to me in uniform, and they would carry their service weapon. Halfway through the school, the Roger Williams changed their policy and said you can't carry on school grounds. So I couldn't carry anymore, and the officer that used to sit next to me, he had to come in uniform with an empty holster. How did that make anyone any safer? In the event somebody did come in with a firearm and tried to shoot at somebody or tried to cause some harm, who do you think is going to be the first target? The officer in uniform, and he's unarmed. How did that make anyone safer at that point. Didn't make me feel safer because I had to be disarmed to go to school at that point. A couple of other things with this. People are aware, they've heard on the TV of the Aurora movie theater shooting. I want to make sure people are aware of this. The individual that committed that crime drove by several movie theaters until he got to the one that was a gun-free zone. The one he actually went in there and went to kill people with was farther from him. He went by other ones. They pick. People that are intent on doing harm pick gun-free zones because there's no resistance. This bill is putting Rhode Island backwards. Last session, this legislature put bills in place to arm our campus police in the event that there's a problem. They can react. They're there. They also extended the authority of our campus police so they can aid local law enforcement in case there's a problem. What message is this sending out to our constituents and people in Rhode Island? K through 12, you're on your own, but when you go to college, we'll make sure there's somebody there to protect you in case something happens. This is a terrible, absolutely terrible bill. I'll move on. 7853. This is a bill that which appears to be the straw purchaser. This is a bill that deals with straw purchases. We're almost there on this bill. The intent of this bill is good. There's a couple of little issues that you could fix, and then we probably wouldn't have any problem with it. In the first part of the bill, it says, no person, entity, or dealer shall sell or loan. The loan part of that in there could cause problems later on with individuals and could subject them to violation of this statute. Okay? So the word loan should be removed out of there. And where it says a transfer of firearm, the wording on that transfer of firearm, it has a very extensive definition in Rhode Island. So if you cleaned up the language a little bit, we probably wouldn't have a problem with this bill. The intent of this bill is good. You just have a couple little things that you could have a problem with. And I'll give you one of the hypotheticals to explain to you why the word loan in there might be a problem. Say you have a couple of individuals that regularly go to the range or they go hunting. So I go to my friend Mike and I say, Mike, let me borrow your shotgun. I'm going to go shooting. And he says, fine. He says, can I borrow one of your handguns? Because I'm going to go to the range also. So I hand him off my firearm. He hands off his. And both of us are legal firearm owners. It's not a problem. And it takes us a couple of weeks before we're going to switch them back. If I'm driving down the road 2 months later and I get pulled over, the officer says, whose firearm is that? Oh, it's my buddy Mike's. What are you doing with it? Well, I borrowed it from him. They're going to say, no, you're not. You guys switched firearms, and you know what? I'm going to arrest you, and you guys can prove that you didn't switch firearms in an intent to try to avoid the transfer on the property. So it could be a problem. It's not the greatest hypothetical in the world, but the word loan in here should be removed, and you should tighten up the word transfer because it's too expansive in the section of law that we're dealing with. So tighten up a little bit, and then we probably shouldn't have a problem with that bill. The gun reporting bill, which is 7244. I think this is a very good bill. The firearms community supports this. It only requires once a year to the Attorney General's office to report to the legislature what it does with regards to its firearm charges and the dispositions. A couple of sessions ago, we were here, and we actually made the comment that the Attorney General's office drops pleads away a lot of the gun charges. Actually, it came back as close to 90% of the gun charges were being dismissed or dropped by the Attorney General's office. The Providence Journal actually fact-checked us because they didn't believe that. Came back 100% true. We made the front page of the paper, if I remember correctly. So when you have people from the Attorney General's office coming here saying, we need the tools to do this, and we need to go after the criminals, and we need to tighten up the gun laws, I want the legislature to be able to know how many of these gun charges they're dismissing or pleading away. Because when you come here and say we need to tighten up the laws, we need to go after the criminals, a little disingenuous when 90% of the charges that you bring, you dismiss or you plea away. Doesn't look too good. And again, the Providence Journal fact-checked us on this. We were 100% accurate. So there needs to be a little bit of accountability on this for the Attorney General's office. I don't think it's unduly burdensome. Once a year, they get to report to you and tell you what they did. Move on to the Reciprocity Bill, House 7541. We support this bill. We asked that this bill be put in for a couple of different reasons. People in Rhode Island, if you ever had to go from Providence down to Bristol, you got to go on, if you go on 136 Metacom Avenue, I'm sorry, 136, 138 Metacom Avenue, there's that little stretch where you're into Massachusetts. If you're a concealed carry holder in Rhode Island, driving down that road, your license in Rhode Island doesn't cover you in Massachusetts. Massachusetts has a mandatory 1-year jail term for individuals that are carrying a firearm that are not licensed through the Commonwealth of Massachusetts. For that very purpose, I have to pay, myself, I pay $100 a year to be licensed through the Commonwealth of Massachusetts just so I can be in conformance with the law. So if I go see my friend down in Bristol, I'm not breaking the law. Cost me $100 a year. This bill would be the first step in having Massachusetts and Connecticut recognize our permits, and we recognize theirs. If Rhode Island recognizes Massachusetts permits and Connecticut permits and other states that have live fire, if this passes, then we can go to Massachusetts and say, look, our firearm CCW requirements are actually more stringent than yours. You should actually recognize ours also. This would protect Rhode Islanders who are complying with the law, who do the right thing, who get licensed. This would protect our Rhode Islanders so that we could possibly get reciprocity back. I think it's a very good bill and necessary first step. 7332, we support that. That would clear up some of the reporting on this. And taking up everybody's time. We'll get to the big one now. 7390. This is the CCW bill. Okay? What the bill does initially is adds a definitional section of what a suitable person is. The concern that we've had in the past with with the Attorney General's office and with the local police departments is there was no real definition of what a suitable person was. So there was a little bit of wiggle room, and the police departments were saying, well, I can add in extra requirements so that I can be satisfied of what a reasonable person is. This bill actually defines it. A suitable person would be an individual who is not precluded from owning a firearm under state law, does not have a criminal history, does not have a protective order or restraining order in place. That individual is, by definition, would be a suitable person. Now, one thing we also did put in there, though, we put in a section which says what a suitable person is not. An individual who a police officer or the police chief or the Attorney General could say that person has gang affiliation. That person, and they have clear evidence of it, that person would not be eligible to get a carry conceal permit. So, in fact, to alleviate any problems that people might have with this bill, rest assured we're not going to be going out there trying to license gangbangers. This bill actually says that they are not suitable people. 1147, and just for a background, there are two enabling statutes for a concealed carry permit in Rhode Island. 1147-11 deals with the cities and towns only. 1147-18 is the enabling statute for the Attorney General's office. Those two statutes are the enabling statutes which allow the police departments to license people for a concealed carry. 1147-11, we start off by codifying it and putting the application into law so that every single police department would have to use the same application. There's a concern right now we have 39 different cities and towns where there's some variations from one town to another in the application process. Shouldn't have that. Should be standardized, so that's why we put it in there. It also reduces some of the requirements. In the past, under 1147-11, an individual had to come forward and they had to present evidence to the police chiefs that their life was in serious imminent danger, that they had a lawful purpose, and they were a suitable person. We reduced that to say if a person has a lawful purpose, then that would be good enough under the statute. It removes the good reason to fear injury. In fact, what it does, it doesn't wait for somebody to actually be assaulted, to somebody to be hurt, or somebody's life to be in the position where their life is in fear of imminent danger, where they need a firearm. It removes that and streamlines the process. This also sets time limits on the police chiefs to actually process the paperwork and give somebody an answer, either yes or no. The current law that we have right now does not have any time frames at all for the police chiefs. They could process your paperwork in a month or in a year. There are people that are waiting 4, 5, 6 months, and they don't know what's going on with their applications. The police chiefs, there's no requirement for them to give you a response by a certain time frame. This puts in time frames. They have to give you an answer. If you are denied, they have to give you an answer in writing why you are denied and state with specificity why you were denied, so that you can find out what you need to do to either fix the problem or you can reapply so that you can get a permit. This is also very important for appeal purposes. Persons that are denied should be afforded proper due process in the event that the licensing agency, the police chief, is denying the person a license. So what we did is we put the Administrative Procedures Act to apply specifically to them, which gives specific steps in the process so a person who is denied can actually appeal this and appeal it within a timely fashion. The requirement of ID, picture ID, date of birth, social security number, those are still all in there. One of the things that we removed in this was there's no requirement that on renewal that you have to put in the 3 letters of reference and you don't have to get the fingerprints done again. A lot of the police departments right now have the digital fingerprinting, if you've ever seen one of these. Once you put your fingerprints on there, they take a digital image of them. It's instantly transmitted to the FBI. They have them. So any time they want to see the FBI fingerprints or get a copy, they just print it. No need to have somebody keep going back every 4 years and getting fingerprinted. Now, we also touch upon in this bill the $40 processing fee. This seems to be a problem with some of the police chiefs. Some of the police chiefs are adding a $250 non-refundable fee up front when you turn in your application. There are other cities and towns that are asking $100 up front. And there are other towns that are putting on administrative fees. You, the legislature, has put this in place and set the dollar figure at $40 for years. And we outlined it and made it clearer. You can't charge more than this. Now, I've talked to some of the police chiefs, and their response is, wow, this is a lot of work, and all we get is $40. My response to them has been, if somebody commits a crime and assaults somebody else, you have to send out your police department, you have to send out the officers, they have to interview the people, the person has to be processed, put a package together, and then it has to go and they have to prosecute them. If the person is convicted of the crime, how much do the police departments get? 0. Nothing. Money goes to the court. So you don't charge the criminal after they have to do all that work. but you want to charge the law-abiding citizen who wants to do the right thing, who wants to be licensed, and has a clean BCI, you want to charge them more than $40 because it's a lot of work. Doesn't seem right when you're charging a law-abiding citizen, but you don't charge a criminal. Now, turn to the AG's processing. 1147.18. We also codify this into law so that this way it doesn't change. It's the same process we'll be having. And by the way, what we did codify into law, the application, is pretty much the same application since my frame of reference is 1996. It's only changed very slightly. What we did change is we put in where the need part of it is changed from a proper showing of need simply to a need. Takes away a little bit of the discretion from the Attorney General's office. If a person's coming in and saying, I need one for work or for that reason, it should be that you have a need. Not a proper showing of need that you have to jump through hoops to convince the Attorney General that you need it. It is simply a need for the firearm, so we made it clearer on that. In addition to that, under 1147.7, and we had talked to Peter Kilmartin about this 2 sessions ago. There was kind of like a little oops in there where illegal aliens, people that have their work visas had expired, people that don't have proper documentation, could be licensed to carry a firearm through the Attorney General's office. It's right in the statute. We put it in there and said, this amendment, it's immediately revoked. If you don't have your proper paperwork, if your visa expired, your permit should expire. So we don't want to have illegals, any illegal aliens having concealed carry permits. Okay. Now, one of the things that we also changed in here was took away the Attorney General office's discretion when it came to retired police officers. The statute the section reads that even if a person has 20 years of law enforcement, if they retire in good standing and have a clean BCI, the Attorney General's office still had discretion whether they were going to give that retired officer a concealed carry permit. I think that's insulting to everyone that's ever worn a uniform, that's ever gone out there and protected the citizens or any type of security and any type of security position. So we changed that and said the Attorney General shall issue the permit. If you have a retired law enforcement officer and they retired in good standing, you give that individual a pistol permit. There's no questions asked. Why do you have discretion on that? That was inappropriate. One of the other provisions we have in here, and we had sat down with the AG 2 sessions ago, and we gave him a very good idea. What happens is this. The AG, the Attorney General's office, when you submit a packet to them and you want to renew your carry conceal permit, it could take several months for them to approve or renew your permitting process. During that time period, if your pistol permit from the AG lapses, if you need your firearm or you need that permit for work, you could be fired from your company because you do not have a permit to carry anymore. The concern is in Rhode Island, and I do a lot of unemployment law through the office, there are several district court decisions with regard to unemployment. If you lose a license that you are required to have for your job, you are automatically denied unemployment. You have to go to a hearing. You have to try to convince a hearing officer that it was either a clerical error or something else happened. So there's a problem, and we tried to fix the double whammy that some people can get. You lose your job, and then you automatically lose unemployment. So we put a provision in there that says, if you need your permit for work, and it's going to expire, you have a valid permit, you have a clean BCI, and there's no change, no substantial change in your need for this. You're still working. That the Attorney General's office within 3 business days will grant you a 45-day emergency extension while they're processing your paperwork so that you don't lose your job. There would be a $50 fee for this temporary license. It would go to the Attorney General's office for processing the paperwork, and then when your 4-year permit is approved, you would have to pay the $40. This would only be allowed one time, and it would just be so that you don't lose your job. That's the final issue I have with that. I know I've covered a lot of bills and taken up a lot of time, so if anybody has any questions on these bills, I'd be happy to answer any questions on them.